Well, good afternoon, everybody. My name is Beth Williams, and I am the Deputy Director of Legal Services for Project Guardianship. We are a recent spinoff of the Vera Institute of Justice, and we've been around serving as legal guardian for about 15 years. And I just want to echo what the judge said in terms of getting more LGBT people into this line of work, because we do have a lot of elders, and I think we are 4 times more likely to not have children, perhaps not have a spouse in our elder years. So we're more likely to be alone in need and need help, which is sort of a scary and sad statistic. But I have had a number of LGBT clients over the years, some referred from SAGE, and it really does make a difference to have that connection, have that cultural competency, and be able to build trust with a person to serve them. So I want to get going on the CLE so you guys can have an idea of what it is you might be getting into if you wanted to do guardianship work and what this all entails. I sent out a PDF of the PowerPoint presentation. You guys can just follow along with me if you want. And there's also a very long PDF of materials that I also sent out, and I'll be referencing some of those things as we go through this. So just to give you an idea, there are several types of guardianship in the state of New York. There is the New York Surrogate Court Procedures Act, Article 17A, which you may have heard about, which is guardianship for mainly adults who are developmentally disabled or intellectually challenged. This is a way for their parents to be able to assist them when they become legal adults. That's what that's used for. And then there's a fairly new guardianship law, Article 83 of the Mental Hygiene Law, which allows for multi-state guardianship issues to be consolidated into one state court, for guardianships to be transferred. And it's really a way to kind of get around the lack of full faith and credit for guardianship across state lines. And then there is Article 81 of the Mental Hygiene Law, which is what we're going to talk about today. So just to go into how do you start an Article 81 proceeding, you need an order to show cause, and you need a verified petition. And this has to be filed in the Supreme Court in the county where the alleged incapacitated person resides. The petitioner has to have standing. This can be the alleged incapacitated person. There's a list here of various people who can do this. It could be a person with whom the AIP resides. It can be a fiduciary of the estate. And then there's sort of a catch-all provision that says any person who's concerned with the welfare of the AIP. And just to sort of, in practice, petitioners are generally APS, Adult Protective Services. They will investigate a case. Generally, there's a referral that's made by somebody in the community who notices that an elder or a person is decompensating and needs assistance. They'll investigate, and if they believe that a guardianship is appropriate, they will bring a petition. And the petition that I included in the materials was one that was brought by APS for the appointment of a guardian of the personal needs and property management of my absolute favorite client of all time, whose name I redacted, but I'll call her Miss C. And I guess maybe the second most active type of petitioner is a nursing facility. So a lot of times what happens is a person will need to be hospitalized. They'll go into a nursing facility, and the nursing facility will not be paid because nobody is managing the finances of the alleged incapacitated person, and they will bring a proceeding to get a guardian appointed so that someone can manage their property and start paying the nursing home bill. Outside of those two, I have seen friends and family petition, although it's very, very difficult for lay people who don't have a lot of resources to hire an attorney to bring a petition pro se. I've seen some some attorneys who were representing a person in a different type of matter bring a petition, like someone who is representing a person in an eviction proceeding might help bring a petition, although there are some interesting conflict of interest issues that can arise there. But for all intents and purposes, it's mainly APS and mainly nursing facilities and sometimes hospitals too. So the notice of the guardianship hearing has to go out to a lot of people. Anybody who is related to the AIP, anybody the AIP lives with, anyone who might be an agent under a power of attorney or a healthcare proxy, the local APS or DSS, the CEO of the facility in which the AIP might reside, mental hygiene legal service, if the person's in a mental hygiene facility. And then of course, there's a very large catch-all, and that's any person or organization genuinely interested in the AIP. So the court wants there to be a very robust opportunity for people who have any interest at all in this person to get notice that a guardianship hearing is going to happen. So when a petition is filed, the court appoints a court evaluator. This is a very important role. This person basically acts as the eyes and the ears of the court, and their job is to interview the AIP and interview anyone and everyone who is helping the AIP, associated with them, friends, relatives, caretakers, psychologists, psychiatrists, and they make a written report to the court along with recommendations for whether the person needs a guardian, what kind of guardianship, how long the guardianship should be, and they give testimony at the hearing. And I've included 2 court evaluator reports for Miss C in the materials that you can take a look at. They're done by 2 different people. And that will give you an idea of how the different approaches to writing these reports and the different types of assessments that can be made. The court almost always appoints counsel to the AIP, and this is generally from the Part 36 list, unless the AIP has their own counsel or they say that they don't need counsel. And we've had people say they don't want counsel, and so they haven't had counsel before, but generally counsel is appointed for the hearing to protect the rights of the AIP. Generally, when an AIP lacks resources, the court often appoints mental hygiene legal services as their counsel. And I don't know if you all are familiar with them, but they're basically an arm of the appellate division, and they're divided into the 4 judicial departments, which range over various geographical areas of the state. And they serve as counsel. They can serve as court evaluator. They do many, many things outside of guardianship as well, and they're generally a wonderful group of folks. So the hearing. So you can't have a guardian appointed unless there's a hearing on the petition. And at the hearing, anybody can present evidence. They can call witnesses, including expert witnesses. You can cross-examine. You can be represented by counsel of your choice. You can actually even request a jury trial if you want a jury trial. And the hearing has to be conducted in the presence of the AIP unless they're just out of state. And sometimes people have a lot of disabilities. They can't get to the courthouse, and the judge and the court reporter will actually go to the person's hospital bed, or if they're in the nursing facility, they'll go to the facility or they'll go to their home and conduct the hearing in those locations too, so the AIP can be present. So this hearing is sort of a very robust evidentiary hearing on the guardianship petition. So what is the standard for appointing a guardian? The court has to determine that the appointment is necessary to provide for the personal needs of the person, including their food, clothing, shelter, healthcare, safety, managing their property, their financial affairs, and the person can either agree to the appointment, in which case they're not deemed or adjudicated incapacitated. They're actually considered a person in need of a guardian or a PING, or the person, if they don't consent, they must be adjudicated incapacitated, and that's defined in the mental hygiene law. So just to give you an idea about what it means for an alleged incapacitated person to consent to the appointment of a guardian, court will consider several things: whether the AIP can really meaningfully interact with the court, whether they understand the proceeding, what's happening, and their ability to comprehend their rights to manage their own person, to manage their own property, that they're consenting to being relinquished to another person or entity. So I just want to think about capacity for a minute with you all. I just put up sort of a rough and ready definition of it here. It's the ability to receive, understand, and evaluate information, and then make, communicate, and understand decisions that are really based in reality and the consequences of those decisions. So there's this sort of tension between capacity versus competence. Capacity is really a legal term, and only a court or jury can make a determination of legal capacity. And the burden of proof is really based on the type of action that we're dealing with, whether it's a guardianship action, a contract action, a will contest. And competence is more of a medical term, and that requires assessing a person's mental status, whether they can perform their activities of daily living, or what we call ADLs, and assessing them for their ability, you know, if they're harm to themselves or whether they pose a risk of harm to others. So those are sometimes concepts that get conflated. So standards of capacity, I think in New York law, there's like 100 different standards for capacity, depending on what type of legal issue that you're dealing with. So this slide just shows 4 of them. So the standard for capacity for medical treatment is one thing. Whether a person has capacity to enter into a will, that is determined by estate powers and trust law. Whether they have the ability to enter into a contract, that looks like it's determined by case law. And then of course, there's also a criminal standard as well. Interestingly enough, you can have the capacity to perform one legal function, like create a will, and not have capacity to perform another legal function, like enter into a contract or power of attorney. Capacity is really interesting. I've had a lot of conversations with people who assess capacity for the purpose of helping a person appoint a power of attorney or a healthcare proxy. And it really is something that can be fleeting. A person can not have capacity one day, maybe they're having a bad day, and the next day, maybe there's an hour where they're very lucid and they're capable of understanding what it is that they're doing. So it's a really interesting, not bright line standard. It also includes the ability to change your mind. And then there's this whole realm of supported decision making, which is another series of CLEs on its own, wherein a person who lacks capacity may still participate in making decisions, but there's a supported decision making model and people that are assisting them with that. So for our purposes, when you're dealing with Article 81 guardianship, capacity requires that the court be persuaded by clear and convincing evidence. So it's that middle standard of evidence. It's not the preponderance, it's not beyond a reasonable doubt, it's clear and convincing evidence that the AIP lacks the capacity to manage their person and or their property. So the court will determine whether they're likely to suffer harm because they can't provide for their needs, and the person cannot really understand and appreciate the nature and consequences of their inability to provide for their needs. And there are a number of factors that are considered by the court. These factors are laid out in the mental hygiene law. The court will look at, really, it's sort of a totality of the circumstances for the person in question. They'll evaluate their ability to manage their activities of daily living, whether they can cook their own food, take care of their home, clean, dress themselves, toilet, and so on and so forth. Those are sort of their activities of daily living. They'll take into consideration a person's preferences for managing their own activities of daily living. They'll look at the nature and extent of the person's property and their ability to manage their property. They'll look at physical illnesses, prognoses, mental disabilities, substance abuse, medications, and the effect of the medications. It's just a really total review of what's happening with that person, which is a really good thing. There's a lot of information that the court is required to get and to consider. And the reason there's so much that the court has to consider and the court evaluator has to do so much due diligence into the person in question is because when a person, if there's a finding of lack of capacity, there's a pretty significant loss of the person's civil rights and liberties. They don't get to make decisions about where they live anymore, or generally their medical treatment, or their social environment, or what happens to their money. So basically, a guardian just comes and stands in the legal shoes of the incapacitated person, and that is a serious divestment of the person's rights. And for that reason, a lot of people don't like guardianship, but unfortunately, it is necessary sometimes. A finding of a lack of capacity is not conclusive evidence that the person lacks capacity for any other purpose, whether it's related to a will, a contract, or any other means. And it's really limited to the least restrictive alternative as the court sort of defines that. So when a guardian is appointed, they want to give the guardian the powers that are restrictive over the person's rights. So if a person, Miss C, for example, was actually very capable of managing her own money. She had a large inheritance from her fiance who had passed away. She kept incredibly detailed logs of her income and her expenses, and she was really on top of it. So there was really no reason for the guardian to not continue to allow her to have her own bank account, her own checks, and continue to manage her money. Even though we were the guardian of property and we could, we really wanted the least restrictive form of intervention. So there's a tailoring of the powers of the guardian to ensure that they're not infringing on a person's ability to manage their affairs if they have that ability. So I threw this one in here. You might want to think about ways to avoid guardianship. If it can be avoided, it's always best, because guardianship is a very long process. It's very expensive. And just unfortunately, people in their planning don't really plan for a lot of these things. So one of the best ways to avoid guardianship is to have a power of attorney, have a healthcare proxy, have advanced directives, so that you have a person who essentially has all of the powers that a guardian might have without having to go through that proceeding, getting family and friends to assist. Sometimes geriatric care managers can do a lot, home health aides, a representative payee if you have Social Security. There are different types of trusts that can be established as well. So there's a lot of things that can be done to help avoid guardianship. And we would like to see more of those things definitely happen for people in the community. But if a guardian is needed, if a court finds that the person lacks capacity or they consent to the guardianship, the master document that sets forth the powers and the authority of the guardian over the person is the order and judgment. And I have included in the materials a copy of the first order and judgment for Miss C when she was a ping, when she consented to the guardianship. And then the second order and judgment when Vera was appointed successor guardian, and that's when she was adjudicated and capacitated after a capacity hearing. So you can see those orders and judgment, how they're crafted, the various provisions that are put into them, the powers as they're enumerated over person, over property. It's a pretty thorough document, and we'll talk a little bit more about what those powers are a little bit later. In the order and judgment, you'll also see, if you happen to take a look at one of these, that the judge appoints a court examiner, and this is different from a court evaluator. The court examiner is the person who essentially reviews all of the reports that are required to be filed by the guardian. So they're kind of the court's watchdog over the guardian, and they review accountings that are filed, initial reports that are filed. Anything that the guardian files, the court examiner essentially will review, and they are appointed from the Part 36 list that Judge Sokoloff mentioned, and I'll talk about a little bit more later. And they also have to complete a training program so that they understand guardianship and what their role is. And the guardian can be different types of folks. It can be a family member, if that's in the IP's best interest. A lot of times it's not, because family members have sometimes taken advantage of IPs. It could be a person that the petitioner has nominated in the petition. It can be a foreign guardian that's recognized in New York. And the qualifications are that you have to be 18 or older if you're an individual, but also nonprofit agencies can serve, social service agencies can serve. Upstate, often DSS is the petitioner and also the guardian, which has a lot of interesting conflicts issues. If APS brings the petition, generally the person is residing in the community, and a community guardian will be appointed. And that's typically JASA, Self-Help, New York Foundation. And when the IP has to go to a nursing facility or be permanently placed outside of the community, those community guardians are no longer able to serve. And oftentimes we are asked to take over as successors. So that's how we get a lot of appointments, but we also get a lot of appointments for cases that are just very, very difficult. There are training requirements. I had to take a day-long course at the Brookdale Center for Aging on guardianship to meet the training requirement. It was much, much longer and more thorough than this short CLE. And if anybody's interested in really in-depth guardianship work, that's an excellent course to take. So how can you start acting when you're appointed guardian? You have the petition, you have the court evaluator, you have the report. You might have a temporary guardianship if the person is in immediate peril. There's a hearing, then there's an order and judgment that's signed by the judge that appoints the guardian. Sometimes if you're a guardian and the person has a lot of assets, you are required to obtain a bond. You're required to submit an oath and designation to the clerk of the court, and the clerk will issue a commission. So a guardian cannot act until they have actually obtained the commission from the clerk of the court. There are several types of guardianship. You can be guardian of the person, the property, both. You can be a temporary guardian or a special guardian who's appointed just for a very limited person or purpose. We were appointed guardian to just establish a supplemental needs trust for an IP. That was it. There was nothing else. You can be a co-guardian. A lot of times a family member will be a co-guardian. And the agency will be a guardian as well, or you can be a successor guardian. The types of guardians, like I said, the community guardian, you might have a private attorney from the Part 36 list, maybe a family member, or an institution or agency like Project Guardianship. All right, just to get into a few of the weeds here. Guardian of the property, this is a big job, especially if you are guardian of a person who has a lot of assets. And I have had clients whose assets range from several $1 million portfolios to people who are completely indigent and have $0 and no way to get any money. So of course, the more complex the finances, the more difficult property management is. But generally, a guardian will have power over bank accounts, safe deposit boxes, sources of income, Social Security, pensions, annuities, any and all investments, insurance policies, valuable personal items. We did an amazing liquidation sale of a collector's multiple personal items. Real property, we've done a lot of real property sales for people who have owned homes or apartments in New York City. Also responsible for taxes. It is quite a job to be a guardian of property, and then to do an accounting of how that property has been managed on a yearly basis. Guardian of the person, so that's generally authority over personal care, social aspects of the person's life, travel, where they live, medical decisions that's made for them. That's more of a kind of care management role. And we spend a lot of time interfacing with people's doctors of all types, nurses of all types, home healthcare aides, psychologists, psychiatrists, just anybody who's providing personal needs care to the person. Very quickly, there are some provisional remedies in the mental hygiene law. One is if you need a temporary guardian or you need a temporary injunction or restraining order, that can be obtained through requesting it in the petition. And if you look at the materials that I provided, APS actually did have a provisional remedy that it was requesting. It requested the appointment of a temporary guardian and also to stay the eviction proceeding against Miss C. So it's a very good example of what that looks like. Unfortunately, that request was granted. Otherwise, she would have been evicted. So there's a lot of reporting requirements if you're a guardian. So the first 90 days of the guardianship, the guardian is required to provide an initial report. That's just an overview of what's been done in those first 90 days. Financial efforts, generally the first 90 days, if you have property management power, you're trying to marshal the person's income and assets, which is sometimes very difficult given that banks and other financial institutions don't often want to recognize the powers of a guardian. So those efforts have to be detailed, as well as any efforts to provide any personal needs management. And then every year there's an annual report that's due to the court, and that's really a comprehensive review of what's happened for that person in that calendar year, and they're due by May 31st of each year. So that's really an accounting of income, distributions, increases and decreases to principal. I included Miss C's annual accounting in the PDF that I sent you all, so you can sort of see what that looks like. We're also required to obtain a medical statement from the treating physician, and that includes all of the diagnoses, the current medications. So it's a very comprehensive report, and it is reviewed by the court examiner. And once the court examiner signs off on those reports, the judge will basically enter an order that essentially recognizes them as filed and complete. We do have people who pass away, and our job is to pay their funeral expenses, any other charges of an emergent nature, income taxes, any bills that might be due before they passed. We have to file a statement of death, and then within 150 days of the death of the IP, we have to file a final accounting. I don't believe I included a final accounting in the materials, but it's basically just an annual accounting without all of the personal needs information. And it goes back to the last approved annual accounting. So we have situations where maybe we've submitted an annual accounting for the last 10 years, but the court examiner hasn't reviewed and the court hasn't approved annual accountings for 5 of those years. So the final accounting has to cover all of those years where an annual wasn't approved. So it can be a rather robust document. I'll say a little bit about end-of-life decision-making, because I think this is a very important part of being a guardian. And I've heard from a lot of people who work in hospitals that we work with that guardians who are appointed from the Part 36 list don't want to make end-of-life decisions for their clients. And this can lead to a lot of problems and a lot of suffering for people. So this is something important that I want to make sure that you're aware of. So the Family Healthcare Decisions Act is what allows a person to serve as a surrogate decision maker for withdrawing life-sustaining medical interventions. In the order and judgment, we are usually given this level of authority to make these decisions for people at end of life. And I just included a slide that has sort of a definition of life-sustaining treatment. This is CPR, nutrition, hydration, PEG tubes, feeding tubes, you know, the sort of immediate interventions that would be needed if somebody were coding and beginning to die if their heart stopped. A lot of times guardians sure if they have the power to make those decisions, and if for some reason the power has not been provided in the order and judgment, there may be a hearing required to amend the order and judgment, which you can imagine is a rather difficult thing to accomplish when somebody is at end of life. But if a guardian does have those powers, they have to be made according to the Family Healthcare Decisions Act. And essentially what we do is we have a 2-physician call with two physicians who are treating the IP. And basically the standard is that the person has 6 months or less to live. And any of these life-sustaining treatments would be unduly burdensome or extraordinarily burdensome to the person. So you can imagine you have a client who's 95 years old. She maybe weighs 90 pounds. If you were to do CPR on her, that would absolutely be disastrous. So we've been very fortunate to be able to help a lot of people pass away with the least amount of suffering through making these decisions for them at end of life. In the rare instance when we have the good fortune to know what the person's wishes would have been for whether they want treatment, we follow their wishes. But if we don't know their wishes, we act in their best interests. We also have the ability to get medical records. So we have access to all confidential medical records. And it's very interesting in the case of Miss C because If you read the materials, she was presenting as somebody that everybody thought was schizophrenic and had paranoid delusions. But when we reviewed her medical records, which it took a while to get, we realized that she'd been diagnosed with frontal temporal lobe dementia, which also presents with delusions. So she had actually been misdiagnosed by a lot of people, the court evaluators, I believe, and a lot of other people during the guardianship proceeding who hadn't seen those records. She really wasn't schizophrenic. And of course, that changes the treatment plan as well. In terms of insurance, if you're a guardian, you have to deal with Medicare and know all the things that it covers. And I just have a very short list of the types of Medicare. Of course, this is constantly changing. Medicaid as well. We do a lot of Medicaid work for people. And generally, if a person doesn't have money, this is how they're able to obtain home care services. And I must tell you, it is always a fight to get the number of hours that a person needs to be safe in the community. And so we have a lot of fair hearings with OTDA over getting managed long-term care plans to provide necessary hours, because if a person doesn't have the hours that they need for home care, then they're going to have to go to a nursing facility. And we all know that's not a great outcome. There are numerous real property and housing issues. If somebody owns a home, we file a notice of pendency. We also have a property manager. We make repairs to people's property. We have to get court authority to sell property. I helped sell a property up in the Bronx. I think it was maybe for $500,000 a few years ago. The Part 36 list also has real estate appraisers and real estate brokers on it. So the court will appoint an independent appraiser and broker to help take care of the sale of the property. We also prosecute evictions, but mainly we defend against them. And we address Department of Building violations, HPD violations. And in the case of Miss C, I didn't include this in the materials, but we filed a discrimination complaint with the New York City Commission on Human Rights because she was being evicted due to her behaviors, which were sort of born out of her dementia diagnosis and that disability. And that was actually very successful because that forced a settlement of the case, and she was able to stay in her home much, much longer. Part 36 of the Rules of Marriage, I included this in the materials because if any of you are actually interested in serving in any capacity in the guardianship world where you might be paid, this is the way to do it. So if you want to be a court evaluator, a court examiner, a guardian, a referee, if you have a real estate license and want to be a real estate broker, this is where you have to go to get on the list to be appointed by a judge. And I included the rules, the application, all of that is in the packet that I sent out. And it all can be done online through the Guardian and Fiduciary Services website. And the GFS, not only are they responsible for managing the Part 36 applicants and enrollees, they're also responsible for coordinating education and training and monitoring and reporting. So that's really the place to go. And I believe I included a link to their website where you can actually see the people on the Part 36 list. There's actually a database there that you can look into, and you can put in whatever parameters you want. If you want to look at New York County and you want to see the list of court examiners from, a year ago until now, you can pull all of them up, see all of their appointments, and you can actually see the fees that were awarded to them, which is very cool because you know how much money people are making for this job. Speaking of fees, Everybody wants to get paid. And unfortunately, a lot of times there's just no money, especially with people who are indigent. But generally, if the IP has funds, compensation to the petitioner's counsel, counsel to the AIP, court evaluator, court examiner, that's paid from the funds of the incapacitated person, unless the person is indigent and they don't have any money, in which case, a lot of times attorneys will accept fees pursuant to 18B. Otherwise, I've seen many instances where people just have not gotten paid, or they didn't get paid as much as they were awarded simply because the money just wasn't there. If you are a guardian, you can take a monthly fee. I believe it's limited to $450 a month. Or you can take yearly commissions, and commissions are a percentage of the income and disbursements that are made and received during the course of the year. So you take commissions on a yearly basis, and the request for commissions is done through the annual report. If you look at the report in the packet that I gave you all, you'll see a commissions page in there. And for the first, I don't know, $15,000, it's like 1%. The next $30,000, it's 2%, and so on and so forth. There are special instances where a guardian can submit a fee application for various types of work performed. So maybe you bring a motion to permanently place a person in the facility. You might also submit a fee application for your time in preparing that motion and the hearing. Sales of real property also lend themselves to fee applications. Filing final accountings and the work it takes to prepare that is also fee application worthy. So there's a variety of ways to get paid in the guardianship world, but I think very few people get rich off of it. I just want to take a quick look at the document that I gave you all. I did include the affirmation of legal services for Pam Walker in the case of Miss C. She's an excellent attorney and served as attorney to Miss C for the capacity hearing. It's very instrumental in helping Miss C not get evicted. So you can see what an affirmation of legal services looks like and what the time was that she put in. Sadly, even though Pam's fees came out to, I'm not sure what they were, $22,875, the judge in this case reduced her fees to about $8,000. So that was unfortunate. I also included an affirmation of legal services for Beatrice Maloney, who was the court evaluator the second time around in this case. So you can see what it looks like to get fees as a court evaluator. So that might be useful if you are considering this practice and like everyone needs to get paid for their work. That's sort of how it's done. I could spend another hour and a half telling you all about this amazing case, which I won't do, but it was an excellent case and a very good example. So if anybody has any questions about this case, if you read the materials later, please reach out to me about it. But I'm happy to take any questions that anybody might have for the last 5 or 10 minutes.
Hi, this is Christopher Chin. I just had a few questions, and I apologize. I'm a little ignorant on the area of law. So, as far as who can actually file a petition, I know you stated that usually it could be a nursing home or a relative or something like that, but this is an involuntary petition, right? So, I guess can anybody just file, or do they have to, have some legitimacy or anything like that?
Yeah, thanks for your question, Chris. I think the statute is pretty broad. but the person has to have an actual interest in the alleged incapacitated person. Like I just wouldn't go file for, Jane Doe, who I've never met and don't know. So the person has to know of and have an interest in the well-being of the alleged incapacitated person to file the petition. And the AIP can actually file the petition themselves if they believe they need a guardian, which I have never seen. I'm not sure if it's happened, maybe ever in the state of New York, but the option is out there through the statute. These petitions are, if you look at it, they're very complicated. I think the one APS filed included an affidavit from a nurse, an attorney affidavit. They also will include a psychiatric evaluation. So it can be a lot to get a petition filed.
My second question is, I know you said that they could consent to the guardianship, but if they can consent, can't they just set it up on their own, kind of like through a power of attorney, as opposed to paying all these fees and jumping through all these hoops?
Yeah, that's a really interesting question. And I think it goes back to what kind of capacity the person has and what their functional limitations are. I've seen people consent to guardianship where I've really wondered if they've been able to validly do so, because it's a lot for a person to understand the proceeding, let alone the loss of rights. But I actually have seen some interestingly high functioning people who have also consented, and they seem to be fully aware of what they're consenting to. As to doing a power of attorney in lieu of a guardianship, in the cases that I have been part of where a high functioning person has been able to consent, I have encouraged family members, the judge, and others to consider executing a power of attorney or a healthcare proxy. But I think when it gets to the point where a guardianship petition has been filed, maybe the feeling is that it's better safe than sorry to have court oversight of what's happening with the person. Because of course you don't get any of that kind of oversight when you have a power of attorney or a healthcare proxy. So it's a way to manage the person's life and express all of these powers on behalf that has a lot of oversight and monitoring.
So if nobody else has a question.
I did something that I hope didn't upset. I'm sorry, you broke up.
I'm sorry. Yeah, no, if nobody else had a question, I had one last question, was whether or not the guardian can actually do something, what they call Medicare or Medicaid planning, as opposed to, putting the assets in trust or, is that something that they're authorized to do?
Yes. And generally it's sort of part of the pro forma template in the order and judgment that the ability to engage in Medicaid planning and handle any sort of administrative procedures that might arise from that is given us a power. And I've engaged in a lot of Medicaid planning this last year with clients who have substantial assets and income, generally to shield their money in various trusts so that they can become Medicaid eligible and receive home care and be able to stay at home in the community much longer than if they were private paying $20,000 to $30,000 a month for home care that they need. So yes, we do a lot of Medicaid planning.
Thank you.
You're welcome. And that's another CLE, all on its own. I included, and I know we're getting ready to end, but I included this very long document in the materials. It is the collected cases in guardianship going back to forever ago. And basically the courts compile this list of cases and they make it available on their website because there are really so few guardianship opinions that are published every year. I think in 2020, there were maybe 5. So this is a great resource to be able to go to if you want to just look at guardianship case law based on topic. That's how it's organized, as opposed to needing a Westlaw or a Lexis password and going that route. So that's in there as a reference point for all of you if you're interested in those cases. Are there any other questions? Great. Well, I'm glad you all came, and I really hope that you learned something. Guardianship is a very, very robust, multifaceted practice. It's a lot of fun. It's very difficult. I think there's a lot of perhaps secondary trauma associated with guardianship because of the dire circumstances that people are in so often, but we definitely need people from our community who participate in this practice because we have so many elders who are in need, and that number will just continue to increase. So thank you all for coming.
And Beth, I want to thank you for this program. It was fantastic. Beth volunteered her time to do this program today. I am going to say that we'll be sending out an email to everybody who is here participating with the video to this program, so you can watch it at your leisure. I know a lot of people came in a little bit late, so you can take a look at this program, watch it with the CLE materials that Beth sent around. And we just thank you for participating. It's so critical that LGBTQ elders have culturally competent and LGBTQ attorneys to care for them. And I think that point was made very well. This was a great CLE. Thank you so much, Beth. And thank you.
You.
Participated. Your CLE code is over there, and you'll need that for the affirmation form, LGBT 99. All right, everyone. Thank you so much. Bye, Beth.
Bye.